Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everybody. Welcome to the historic courthouse here in Morganton, and your Supreme Court certainly appreciates the hospitality of all the folks here in Burke County and in Morganton. In 2004, well, our state constitution provides that we will hold court in Raleigh and such other places as designated by the General Assembly. And in 2004, the historic courthouse in Edenton wanted that designation for us to come to Edenton and hold court, and so the General Assembly saw fit to do that. And then in 2015, I think it was, somewhere in there, Justice Ervin and I went to the General Assembly. Senator Daniel, certainly, I think he sponsored the bill to allow Morganton to be the site where we would come in the West. This setting is certainly appropriate for the Supreme Court, since in the late 1840s through the early 1860s, the Supreme Court would come here and hold court in August. So in some ways, I guess we're just returning home. But again, we appreciate all the hospitality that the folks here provide for us in our visits. You see 6 of us, but we have 7 on the court. Justice Hudson is joining us, but she's having to do so from home. She's going through all the protocols. We hope that she is feeling well, and she may participate just by texting in some questions to Justice Ervin. So if you see him checking his phone, it's not social media. It is checking to see if Justice Hudson is submitting some questions. She will participate in the decision in all the cases that we'll have, but she is viewing it remotely. We are live streaming this for anyone who desires. You know, we look at the bright lining of COVID, and one of those bright linings are our uses of technology. And we live stream now all of our Supreme Court arguments. So here in Morganton and Burke County, you're able to watch the exhilarating arguments that are made before our court. So after you sit through this morning, you're going to be hooked on, man, when can I see the next one? Well, stay tuned. Speaking of COVID, sadly, one of the attorneys in case 6 told us yesterday that there had been a positive COVID test. So for any of you that know anybody who is scheduled to be here tomorrow for the 3rd case, which is our case 6, please let them know there will not be an argument for case 6 tomorrow. You know, it's just part of the world in which we live right now. Is you know, we keep hoping and praying that COVID will be something in the rearview mirror, and just when we think it might be, it pops up in the windshield again. So anyway, all those little announcements being said, our first case this morning is in re LNH, and we will hear from the appellant.
Good morning, Chief Justice Newby and Associate Justices. May it please the Court, my name is Mercedes Chutt. I'm arguing on behalf of the appellant petitioner, the Guilford County Department of Health and Human Services. My colleague, Mr. Matthew Winchie, is arguing on behalf of the guardian ad litem. We will be sharing our time. We hope to have 12 minutes each and 6 minutes for rebuttal. It is our plan that I will argue about the ineffective assistance of counsel issue and the evidentiary issues, and that Mr. Winchie will argue about the issue pertaining to whether, in deciding dependency, the court can consider post-petition evidence. So starting with the ineffective assistance of counsel issue, this case has significant implications for ineffective assistance of counsel because it is the department's position that it sets the bar so low for ineffective assistance of counsel, or IAC, claims. In this case, the mother's counsel did not object to evidence that had been admitted in a prior proceeding. The evidence at issue was the medical records pertaining to the injuries of the child. The facts of this case are that the minor child, who was 10 weeks old, sustained burns to her feet and had swelling in the abdominal area. The biggest injury was the burns to the feet. The medical records established the child did receive burns to the feet, as well as swelling in her abdomen, and that she was hospitalized for 2 days.
Ms. Chutt, just to ask you a question about the content of the record. Many of these issues involve references to the medical records. There are some medical records in the printed record. Are those the medical records that we're supposed to consider in evaluating issues in which the medical records are relevant?
Yes, Your Honors. The medical records in this at issue were contained in a reasonable efforts report, and those are on pages 20 to 33 of the record.
So when you and Mr. Wunsch and Mr. Miller talk about the medical records, those pages are the records that we need to look at?
Yes, Your Honor.
Okay.
Yes.
There's not a separate exhibit or anything like that?
No, Your Honor. So what had happened was...
Before you go too far, can you explain how the report would have been used? Was it just presented to the court, or was it, how did it become part of the record, I guess is what I'm asking you about.
Right, and so we don't really know the answer to that question because the hearing, there was a 7-day hearing, which is a hearing on the need for continued non-secure custody, which by statute has to occur if the parent does not waive those hearings. And one of the things that the court can look at in a 7-day hearing is whether there is a reasonable basis to believe that abuse and neglect and so forth occurred. We don't know what happened at that hearing because there's no transcript and nothing in the record shows what was happened at the hearing. There's no narration of evidence or anything. All we know is that following that hearing, the court entered an order, which is in the record on page 35, in which the court found that the reasonable efforts report was admitted into evidence, and it incorporated the reasonable efforts report into evidence. And so in terms of was an objection made at that time, did the mother consent to it? I think there's an allegation that, or it was in Mr. Miller's brief that the mother consented to the records coming in. It's not in the record. Nothing, the only thing in the record that gives any evidence to what happened is that order. It's on page 35 of the record, where the court found that the medical records were admitted into evidence and incorporated them by reference.
Aside from the attorney's failure to object to those records coming into evidence, in all other respects, was the attorney vibrant and active in terms of representing the mother's interests?
He absolutely was. And one thing, so the attorney made several objections. He cross-examined witnesses. He made a closing argument. And I think one thing that's really important to note is I think the Court of Appeals assumed that the trial judge relied on hearsay in the medical records in making its findings of fact. The medical records contain hearsay about reports from neighbors or observers about how the child was injured.
Would this court be setting a relatively low bar for ineffective assistance of counsel if, on one hand, counsel was in all other respects being very active in terms of representing a party's interest, but yet on the other hand, but for one perhaps strategic or perhaps otherwise omission in representation, that we would be holding such to be ineffective assistance of counsel?
My concern is that the low bar requires counsel to object after the judge has already ruled. The record is very clear that all the attorneys believed that the judge had already ruled on the issue of the admissibility of the medical records. Note that this was the same judge that was hearing the adjudicatory hearing that presided over that 7-day hearing where the medical records came in. And there was an agreement among counsel that the judge had already ruled. And I think it's problematic to establish a standard for ineffective assistance of counsel that requires counsel to continue to object after the judge has already ruled.
Is it your position then that it is not so much the quantity of errors or omissions that a counsel may make, but the aspect of how pivotal it is in terms of even one singular omission?
Well, I mean, I'm sure one singular omission could establish ineffective assistance of counsel in some cases. My argument for this case is there was no error. What the record doesn't reflect that there was any error, and with ineffective assistance of counsel cases, the cold record needs to reflect that there was an error.
Is your argument to this point then that everything that's admitted into evidence at a non-secure custody hearing then is already admitted and can be considered at a subsequent adjudication hearing?
I think when you're talking about a narrow evidentiary issue as to whether or not records were admitted,
Well,
it can't.
if that wasn't clear, let me try again then. The medical records in question were attached to something that was admitted into evidence. We don't know under what circumstances at a hearing held for the purpose of determining whether non-secure custody should be continued, right?
Correct.
Is it your contention that anything admitted at that hearing is then deemed admissible at a subsequent adjudication hearing?
Not necessarily, no, but I do.
How do we know what is and what isn't then?
Because in this case, the judge made a finding of fact that it was admitted.
But assuming that it was admitted at the non-secure custody hearing, whatever the piece of evidence is that evidence then, because of the fact that it was admitted at a non-secure custody hearing, admissible in an adjudication hearing?
In this case, I think the answer is yes, because everyone agreed about the admissibility.
Why would there be a different rule depending upon what kind of evidence we're talking about, which is where I think you seem to be headed?
I mean, it's just a gray area. So this court has held that courts can take judicial notice of findings of fact in proceedings that do not require the rules of evidence and have a lower evidentiary standard. And I think what is supposed to be the safeguard here in terms of what's probative evidence and what isn't is a trial court. Because the trial judge sitting without a jury is presumed to disregard incompetent evidence. So I don't think there's anything in this record that would establish the judge did not disregard the hearsay reports as to how the injuries occur. If that information was disregarded, then where is the evidentiary support for the findings concerning the holding of the lighter or whatever it was to the child's foot, to the leaving the child on the porch, to the neighbors intervening? If the support for those findings isn't from the testimony of the social worker, which was expressly admitted for purposes other than hearsay, or from portions of the medical records, where does the support for those findings come? Okay, so to answer your question, the court did make findings about the report. And the findings about the report are necessary to show that the department had jurisdiction to investigate this family.
Well, and I don't think anybody questions that, but I mean, there also, isn't it important whether those things actually happened as a matter of fact?
It actually is not.
Okay, why not?
To answer your question. So the reason why is because it isn't necessary to establish causation to show either neglect or abuse. So for abuse, one only needs to show that a child received injuries that were not accidental in the care of the parent. It isn't necessary for the court to determine how the injuries occurred. With neglect, it's only necessary to show that the child was in an injurious environment, and as we all know, that the fault of the parent is not an element in either abuse or neglect. And if you read the order carefully, I would submit that the trial court did not find that the mother had done all the things that the so-called neighbors reported. So the trial court didn't find the mother had, swiped the lighter over the child's feet, sprayed some green liquid on the child, beat the child in the stomach. The trial court did not find that. That was the so-called neighbors report. The trial court only found that the child was injured, and if you notice, all the findings are their passive voice, was injured. The injury occurred in the mother's care, but not that it happened the way the neighbors reported it to happen.
But wouldn't those findings of the parent's fault and causation be necessary for the trial court's, the part of the order that eliminated reunification and reasonable reunification efforts for the mother and at this initial permanency planning order?
Well, in my opinion, no, because if you look at the catch-all provision under 7B 901CF, the reunification efforts can be ceased by any conduct that enhances the character or the abuse or neglect. And my argument, is there that basically for neglect, for example, it isn't necessary to show that the child was actually injured for neglect. It's a risk of injury. And also, it's not necessary for either abuse or neglect to show that the child was seriously injured.
But wouldn't it be necessary to show that the parent was in some way at fault or caused the injuries in order to eliminate reunification as part of the plan?
In my opinion, that's not in the statute. If you look at the catch-all provision, it only states that there has to be some evidence to enhance the character of the abuse and neglect. Also, the court can consider those reports, the hearsay reports, a disposition.
Then, just one other quick question, because I know you're running out of time. Isn't it true at the 7-day hearing that the mother was not represented by counsel? She did not have counsel yet.
I do not know that.
Because wasn't there an order appointing her counsel at that same hearing?
There may have been, and I don't know the answer to. I'd have to look at the record. That could be the case.
Thank you.
So my point with IAC, ineffective assistive counsel, is simply that, here you have to, I would argue there wasn't a mistake made by this attorney. I don't think it's a mistake to agree among counsel that something has already been admitted into evidence. And I don't think that the standard should be such that counsel is required to continue to object, ask a judge to reconsider their ruling when it's already been made. And I would argue there's nothing in the record to suggest.
But Ms. Chutt, don't our appellate procedure rules provide in essence that if evidence is admitted without objection, even though it might have been objected to at some other time, the objection's waived?
You're saying that the parent,
saying
I think so. I think that the objection would have been waived. And I think that's another problem, that I think this is just a real stretch here to say that this attorney did anything wrong. Particularly when, you look at if you look at the transcript too, even in his closing arguments, page 25 of the transcript, he makes the argument again that the judge should not consider the hearsay reports about the neighbors, what the neighbors saw in the court's adjudication. And he objected when that came in terms of having it being used for the truth of the matter asserted. So I think it's a case where it's hard to find what the attorney did wrong at all. Okay, and my time is up. Thank you.
Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Matt Wunsch. I'm appellate counsel for the Guardian Ad Litem program, and I represent the juvenile LEA before you today. I'm going to focus on the dependency issue, but I did want to respond in one way to Justice Earle's question about the ceasing and the evidentiary issue with the ceasing part of the order. I don't want to step on Mrs. Schutt's issue here, but I did just want to mention that causational finding, I think that Your Honor could, the findings to support ceasing are dispositional findings, and so they don't need to be made according to the rules of evidence. It's whatever the trial court finds to be relevant and reliable evidence. Hearsay is expressly allowed in disposition. So even if there was a hearsay issue with that evidence required to make the finding of fact that Your Honor was talking about, it wouldn't matter for a dispositional finding. But the issue that I want to focus on before you today is the dependency and the post-petition evidence issue. Your Honors, if we have a system where different rules apply at different cases, we can't do justice for all children and families, and that's what we have right now. We have an ad hoc rule for what evidence is admissible to support adjudications of abuse, neglect, and dependency, particularly dependency as the case law has evolved. So there are three main points that I want to focus on as I talk with you about this issue today. The first is that the plain language of the Juvenile Code is clear that the critical moment for an adjudication is, or the critical determination is the existence or non-existence of the allegations in a petition. Second, that limiting adjudications to that particular moment in time provides clarity for all the parties involved, for parents, for children, for DSS, frankly, who has the burden of proving those allegations. And that certainty is good in any context, but particularly in this context where the issues are so important. So there should not be an exception for post-petition evidence to come in at adjudication. And then finally, as an alternative, if the court wants to continue to extend this post-petition evidence exception, that it should truly be narrow in scope, that it should truly be for immutable conditions, for things that are truly fixed and ongoing, not ad hoc to be decided on a case-by-case basis. Turning to the first point, Your Honors, the plain language of 7B802, which is the determinative statute here, says that the existence or non-existence of any of the allegations alleged in the petition is the determination the trial court has to make at adjudication. That's the plain language of the statute. It's unambiguous. The analogy that I think of is to an indictment in a criminal case. Now, it's not the same determination because we're not proving fault. It's about the status of the child, not the fault of the parents. That's another very important consideration here. But there is an allegation that has to be proven or not, and there's a particular time at which that happens. I look back at the history of the statute, and that has been the same since it was enacted more than 20 years ago. That moment is the one that was fixed as the moment that matters. And the initial case law from the Court of Appeals was very clear, in Re AB, in Re JR, where parents had asked for the court to make an exception to that rule. No, that the plain language of the statute is unambiguous. That's the point in time that the General Assembly has set, and so that's what is going to have to be evaluated. What were the conditions at the time the petition was filed? Post-petition evidence, those cases...
Let's talk about the language of the statute a second. It says adjudicate the existence or non-existence of any of the conditions alleged in the petition. I mean, I could probably, if I put my mind to it, interpret that two or three different ways if I thought about it a little bit. The issue is you have to find the condition, which would be either abuse, neglect, or dependency. It doesn't say as of the time of the petition. It says alleged in the petition, the condition alleged in the petition. Why should we read that language the way to be plain and unambiguous in the sense that you have argued in your brief and argued here again this morning?
Well, Your Honor, I think the language is plain in that it's saying that the existence or non-existence of any of the conditions alleged in the petition that fixes the point in time at which the trial court is supposed to evaluate the evidence. So evidence of things that happened after the petition necessarily were not conditions that were alleged in the petition, and those conditions could change in either direction. You know, we have a relatively short window of 60 days from when a petition is filed to when an adjudication hearing is supposed to happen. And you see in the case law it going to the benefit of one party or the other in different cases. Conditions could improve, conditions could worsen, post-petition evidence, and maybe I need to clarify too what I mean by post-petition evidence. I've just been using that term without really explaining what I mean by that. I don't mean evidence that came to light later of conditions as they were at the time of the petition. I mean evidence of conditions after the petition was filed. So circumstances
okay,
and I apologize if that was not clear.
Let me make sure I understand what you're saying then. In this issue, in this case, the real issue appears to be whether there was an adequate alternative arrangement for the care of the child. We've got some folks, and I understand your argument that mother didn't present some of these people, but putting that aside, let's say hypothetically, the mother had suggested these other folks that came to DSS and offered to take, assume responsibility for caring for the child. If, as a matter of fact, at the time of the hearing, these folks were an adequate child care alternative, would that preclude a finding of dependency?
No, I don't believe so, Your Honor.
Why not? Because I think I understood you to concede that if the fact existed at the time of the petition, then you could consider it, even though it might involve other information over a broader period of time. Why would?
Oh, well, I'm sorry, I apologize. If I said it that way, I misspoke, Your Honor.
Well, that's the way I understood it.
Okay,
and
I
the reason I asked you
apologize.
about it was because I did not think that was consistent with what I'd understood your argument to be.
No, I mean evidence of conditions that evolve that could not have been known at the time of the petition. So that's the condition, that's the circumstances we have here.
But so you're saying that in the event that these folks were in actuality, as of the date of the petition, capable of providing care for the child, that evidence doesn't have any bearing upon whether the juvenile was dependent?
Not if it comes to light post-petition. Correct, Your Honor. That's a dispositional
if you find out
issue.
about it, so your argument is, even though it may have been a fact as of the time of the petition, if that wasn't known to somebody, I don't know who we're talking about exactly, DSS, the court, whatever, that fact doesn't have any bearing upon whether this child was dependent.
That's right, Your Honor, because it's not an allegation in the petition. The allegations in the petition are that there's no caretaker, the parents are incapable and there's no alternative caretaker available. And so the DSS agency who has the burden at that point is responsible for showing or not showing, trial court's responsible for finding or not finding those conditions as alleged in the petition. The post-petition evidence, and this case is a good example of that, in that you have the relatives who offer themselves forward, but you can see in the record the evaluations don't come in until after the fact, after the petition is filed.
Well, is the important thing what DSS thinks about them, or what in fact was their set of circumstances?
Well, I think it's what's known at that time, Your Honor. So it's not really a question of what they think about them.
Known to whom?
Well, known to the trial court, most importantly.
Well, the trial court's only going to hear it sometime later. It's not
Right.
going to hear it at the time of the petition, so I'm having trouble seeing why the trial court's knowledge would be determinative of what was a condition, what was true as of the time of the petition.
Well, because there was no party that knew it at that time. I mean, in this case, Your Honor, in particular, we have the relatives who come forward. They aren't offered by the mother as a potential placement. Only after the fact is it determined that they are, and one of them is a good placement for the child. Ultimately, as it should be, that's a dispositional issue, and it's a good result, I think, for everyone involved, is that the child is placed with a relative. It's a dispositional decision that is made if that placement is appropriate, and it turned out to be in this case. The problem we have is conditions change. Child care placement options change over time. Again, we're talking about a relatively short window between the time a petition is filed and the time an adjudication should be heard, but things can change back and forth in that time. A relative could move, their home could change. As we had in this case, you have another family member living in the home who needed to leave before it became an appropriate home to place this child. So that's something I think even evaluating the evidence we had about that placement, it was not appropriate at the time the petition was filed. That had to happen before it could be approved and before it became a placement option for the child here. So even in that window, it doesn't really work. But what we have now is cases going up to the Court of Appeals and different panels deciding, okay, what is a fixed and ongoing circumstance, and reaching different results. We have paternity, which to me sort of stands out as the one fixed and ongoing circumstance that isn't going to change once it's established. We have one panel saying substance misuse. Well, the parent has addressed her substance misuse since the petition was filed, and so now that's a fixed and ongoing circumstance. We have another panel talking about housing, unstable housing. Well, that's been resolved. Now that's a fixed and ongoing circumstance. I think anybody that works in this area of law knows that those are extremely, extremely changeable circumstances. They are not fixed and ongoing. They are what our cases are about, that parents have a substance misuse problem and relapse and get back on track and relapse. And unfortunately, it's a sad story, but it's the kind that we see over and over again. So I urge the court, if the court is inclined to keep the exception, I think the bright line, clearest answer is to go back to the AB standard, to the statutory standard that I argued for, to make it the evidence at the time the petition was filed. What were the conditions at the time the petition was filed? But if the court is going to keep the exception, to truly narrow it, and I've thought about this a lot, I cannot think of another condition that is analogous to paternity in this way, that is truly fixed and ongoing, that is not going to change over time. It's just not the nature of our cases. And I apologize, I see that I have eaten into our rebuttal time. So if the court has no further questions, I will just ask you to reverse the Court of Appeals.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Mr. Chief Justice, Associate Justices, I'm Jeff Miller from Greenville, North Carolina. It's an honor to be here today representing the respondent mother, Loretta Ford, and the correctness of the Court of Appeals decision in this case. To get right to the heart of the matter, it is my position that there is not a high bar or a low bar for effective assistance of counsel. There is a bar that we hold licensed attorneys to that's reasonable, that has objective standards of practice, and when there's a failure, we recognize it as a deficiency. It is not a criticism necessarily of the person. It is a bar in the practice that's an important one. And in this case, the lawyer failed to object to the only evidence that supported the trial court's decision and adjudication, the hearsay evidence with regard to the mother's conduct and behaviors, and the ultimate status of the child. I would point out one thing that I think is important as we look at this, and I know that we speak a lot about the status of the child and nobody being at fault, but if you read the definitions of an abused juvenile, it requires that the parent inflict or allow to be inflicted the harm to the child. So it does require conduct on the part of the parent. Similarly, in injurious environment cases, you might have an innocent parent and a parent who keeps a child in an injurious environment. Just because there's an innocent parent who's not at fault that child's status can still be a neglected juvenile. In this case, the only evidence that came before the trial court that supported its order was evidence that was not admissible because it was hearsay evidence. It was not competent, it was not clear and convincing evidence, and it was not evidence that our statutes say we must rely upon when we adjudicate in these constitutionally important cases, cases that involve fundamental family relationships.
Didn't the trial court say that the evidence was being admitted by the trial court, not for the substance of it, but merely to respect what DSS was saying, which was this was the way in which DSS came to be involved in the first, or DHHS came to be involved in the first place?
Justice Morgan, there are two instances with regard to the identical evidence. And the first instance had to do with the report itself. And when that testimony was proffered as the reason why DHHS became involved, this trial counsel objected to that evidence as hearsay, and it was acknowledged by DHHS and by the court that it was not being admitted for its truth. So that objection prevailed. To some extent, though, the court's order seemed to, and I think the Court of Appeals felt, seemed to use that evidence in its decision. The second occasion, though, is where the lawyer's failure comes into play. And this is critical because the evidence that was involved came into play at a non-secure custody hearing where evidence, hearsay evidence, is admissible and is appropriate for that temporary and that limited decision protocol. And we know in this case, the court's finding says that it was accepted into the record as part of today's evidence, a previous exhibit admitted in May 10, 2010. Doesn't say how it was admitted, doesn't say anything about there was a subpoena or that there was a witness or anything of that nature, but it was admitted by judicial notice, not through any authentication or offer, and the record is clear what happened. And I have indicated that it is a bit galling to say we don't know what happened. We do know. The record shows that a reasonable efforts report to which this limited medical record was attached was submitted on May the 10th when Loretta did not have a lawyer. Her lawyer, the record shows, was appointed May the 10th. And Loretta, at that time, consented to the non-secure custody order because she just got served with a petition that day. She just got a lawyer that day, and nothing had really been decided in the case.
But as to ineffective assistance of counsel, wouldn't we as a court be perhaps dangerously lowering the standard for ineffective assistance of counsel if counsel was, in all other respects, even including the first opportunity to enter an objection which was sustained, to be able to say nonetheless that the counsel was somehow deficient?
I think that the case law, at least the Court of Appeals case law, is very clear that when hearsay evidence is the only evidence that supports an adjudication, that it is prejudicial error to not object to that and to allow that evidence to come before the court. We're not lowering the bar. And as a lawyer who practices in the court, we ought to maintain a high bar for practice. We ought not to be saying to DHHS, to the courts, or to lawyers practicing in our juvenile courts where children are being taken away daily, adopted out, where families are disrupted for periods of time. We ought not to be saying to them, well, we've got a low bar if you don't object to the only evidence that will establish the adjudication of a child as abused or neglected. And in this case—
Mr. Miller, let me, to follow up on the question that you were just asked, I had generally understood that we looked at allegations of ineffective assistance of counsel on an issue-by-issue basis rather than trying to evaluate whether the lawyer's overall performance was adequate. Do you?
Your Honor, I honestly, I've been involved in a lot of cases where ineffective assistance is alleged and where sometimes the Court of Appeals or this court on occasions notices it. And it is indeed, I think, on a case-by-case basis. And where we get into the questionable area is if we can discern any strategic or litigation purpose in what the lawyer has done rather than some on-its-face deficiency.
Well, and I guess that was going to be my next question. I think this court has held in a criminal case is the question of whether an attorney acted on the basis of a strategic or tactical decision was a question of fact, so that we shouldn't hypothesize whether there was actually a decision made, but it required a factual finding as to whether that was the case or not.
And in looking at this case, there is no way for this court or anyone to even say that there's a factual issue here about a strategy or a litigation purpose.
Well, I mean, let me posit you a situation and see what you think about it. The information to which you object is contained in a number of places in the record. You've already talked about the testimony of the social worker. There's also a summary of these statements in the medical records. Admittedly, you have hearsay upon hearsay issues with respect to the medical records, but would it be a tactical decision to say, in effect, if they really want to take the time to bring in the custodian for these medical records, they could get them authenticated anyway? I'm going to look bad if I waste the court's time making them prove something that they can prove pretty easily if they just bring somebody else here. Therefore, in order to avoid irritating the court, I'm not going to make them do that. Would that be an unreasonable decision in your view, assuming that that was the decision that was made?
Your Honor, if you're asking me, I'm going to say very clearly and without hesitation it's an unreasonable choice to say I'm not going to put DHHS to the test that the statute requires in order to adjudicate abuse and neglect and, in effect, as happened in this case, terminate a parent's entire rights.
Of course, at the time that the counsel did or didn't object, it would have been a little hard for the counsel to know that you'd get the subsequent finding of a lack of no necessity for reunification.
In this case, Judge, I don't believe that there was any question about what the posture was going into the trial, but the record is not clear on that. I will have to concede that.
Because in looking at it, it appears to me to be something that came up during the course of the hearing. I didn't see anything. I may be wrong, and please point me to it if I am. I didn't see anything earlier on that asked for a cessation of efforts of reunification at this hearing before the hearing.
There was not notice of cessation of reunification given in writing in any sense in the case. Counsel did, in a statement of the court, ask that the permanency planning about the reunification be continued and not be held at that time. But what I want to say, Judge, is, Justice Irvin, is this issue is not a low bar issue. It is a hearsay issue. It is a fundamental evidence issue, a matter of law that is clear. There is no excuse for saying, I'm not going to put somebody to the test. The truth is that record, we don't even know who's saying things. We don't know where these statements came from, how many neighbors are involved, how many observers are involved, who's saying what to who. We don't know any of that.
So in your view then, and I've got one more question beyond this one, but this is one that Justice Hudson wanted to ask. We're going to try this technique for a while. What, in your opinion, should the lawyer have done specifically at the hearing?
In terms of at the trial, should have objected to the judicial notice of a non-secure custody order document that was introduced with hearsay in it, because, and there is a Court of Appeals decision, the JMCJM case, that explains the dangers and the problems with allowing a court to take judicial notice of non-secure custody hearsay type hearings, hearsay information in making adjudication decisions. They recognized that problem. And it is fundamental that if that is the only evidence that the lawyer has acted deficiently, that there is no question of prejudice, and that there's a reasonable probability, had that evidence not come in, a different result would have occurred with the adjudication of abuse and neglect.
Let's say, I mean, the Court of Appeals held, among other things, in its opinion, if I'm reading it incorrectly, tell me, but this is the way I read it. In essence, this evidence shouldn't have been admitted. Therefore, the findings lack sufficient evidentiary support. Therefore, the adjudication is reversed. Is that a fair reading of their order?
The adjudication of abuse and neglect was reversed.
Right.
The dependency was a different.
Right. Typically speaking, when you have an evidentiary issue, the remedy is a new hearing, not reversal for insufficiency of the evidence, isn't it?
As I read the opinion, it reversed and remanded, contemplating that there would be some type of new hearing.
Okay.
It reversed completely the dependency adjudication. So I do think that it's absolutely important and critical that we recognize this was the only evidence that supported this entire order for the adjudication of abuse or neglect.
Mr. Miller,
Yes.
if I might interrupt, I'd like to take you back to your discussion about what abuse is and what neglect is,
Yes, ma'am.
and particularly neglect. The way, and again, setting aside your legal arguments about hearsay, the way I read the facts of this case as they were found in the order, that this the mother took 2 shots of vodka, went to sleep, put her baby to bed, went to sleep, and woke up with her baby severely injured in the hospital. How do you reconcile that to not be neglect when a mother goes to bed having had consumed alcohol and inexplicably her baby is carried off to the hospital?
There's a lot we don't know about what occurred at that time, but we do know that the law says injury alone is not sufficient to support a neglect adjudication. We do know that. We do know that taking a double shot of vodka is not neglect by a parent under any stretch of the law and the determination. All we know, we don't even know who else lived at this residence. All we know is that this mother put her baby to sleep, took a double shot of vodka, and went to sleep herself, like so many others do. How it transpired from that point on, we don't know. There's not evidence in the record that allows this court to simply jump to an adjudication of neglect under the statute that makes the case basically on facts from which a court could make findings. That does not alone constitute that neglect.
I think Justice Hudson would like to ask, is there any evidence from which one could find that anyone else was the perpetrator of these injuries?
Of course, the burden is upon the department. The evidence was sparse in this case on adjudication. I think it was about 16 pages of a transcript. And it, like so many of these cases, there are just assumptions made and practices conducted very quickly without really figuring out what occurred. You know, this mother was never given an opportunity to explore with anybody what occurred. She didn't remember. She was very candid about that. I want to also remind the court, this is a young mother who had no prior history with the department, who had no criminal record, whose family said she was a good mother to her child, always acted appropriately with her child, who, when she was arrested, while she's in jail within the course of just a few months, completes parenting classes, anger management classes, is asking to have a therapist, who is doing all things right. So we ought to have a lot of questions about what occurred here, what did occur, and the evidence just is not there sufficiently, clearly, convincingly, competently.
Well, there's no dispute that this child's feet were severely burned.
Judge, there was a partial thickness burn, and I will say that is a serious injury. I will not try and argue about that issue at all. It's akin to, if you read the literature, sunburn, scalding with hot water kind of burns.
Well, it also got infected, at least in the left foot, which caused some follow-up visits, that type of thing. And there's also no dispute that the mother was arrested for these injuries. Isn't that correct?
There is no question she was arrested. She was in jail when she was talked to by the agent.
And certainly we expect the role of DHHS to protect. In this case, the child was about not even 2 months old.
That's
when
correct.
This child was burned.
That's correct. Those facts are indisputable. There's not any question about that. The question is what is the evidence that supports an adjudication under our juvenile law? And we have a standard for that. We have a rule of law. We are consistent that we defend the Constitution and the rule of law.
When a 1.5, 2-month-old child has severe burns on her feet, certainly that her status, the status of the child, is having been neglected.
The case law is clear that an injury alone is not sufficient to adjudicate neglect. I think there are numerous cases to that effect. It requires more. And that's what I'm here about is it does require more. And the problem in this case is not only was this mother treated so severely in terms of the error that allowed the adjudication of neglect and abuse to occur, but in terms of the kind of mother she was and allowed no opportunity. She, in effect, had her parental rights terminated. She wasn't given an opportunity for WebEx visits with her child or for supervised visits with a sheriff or in a family center or in any type of relationship at all.
There's no dispute that medical records are routinely admitted into evidence in courts across the state with regard to hearsay exception. Isn't that true?
It is true in a limited sense, Judge. There is case law, and I've cited it, State v. Smith, that hearsay statements within those medical records can still be subject to objection.
But we also know that one of the reasons that medical records are admitted is that there's a common sense understanding that people give accurate statements to the medical providers for medical care.
Chief Justice Newby, that's correct, but it requires further explanation. That rule, the medical treatment exception, is based upon the patient coming to a doctor and saying, here's what happened, here's what's wrong with me, and that they're motivated to tell the truth about that.
How did this 1.5-year-old child get to a medical provider? Did the mother take her?
Judge, I was going to go on. We do have an exception also that says parents of children can provide that information for these young children. Here, we don't even have a name. What we have are neighbors or observers, and we don't know how many of those.
Where was the mother?
The mother was in her home, asleep.
Well, I think there's some testimony or evidence or statements that she ran away.
The mother ran away?
Yes. I mean, if you look at what the neighbors said, they said she got a lighter out, that she sprayed the child with some kind of green liquid, that she hit her in the stomach, and then when the neighbors came over, the neighbors said she ran away.
The actual testimony is, and it's recited in my brief, says that the neighbors took the child from the mother and she went in the house. And again, we don't know what happened with this mother. A single isolated incident she doesn't remember and can't tell us. No one took the opportunity to even explore that. And I think that that's critical to remember in this case, Your Honor.
The record contains two different descriptions of statements that your client made to DSS workers. One, the same witness testified to both of them. They were pretty similar. That evidence is admissible for the truth of the matter asserted. It.
As I indicated in my brief, there's no objection to that evidence. And
even if there had been, we can quibble about whether it's an admission in the lay sense of the term, but typically a party's statements concerning past events are admissible.
That's absolutely correct. Yes,
And
sir.
so the trial court, regardless of whether anything else was subject to being admitted, could consider that testimony.
And that testimony was,
Well, that testimony was, as I recall it, and correct me if I'm wrong, because it always helps me to make sure I'm understanding it correctly, is that the child was with the mother. They were in the home. The mother drank vodka, went to sleep, and the next thing she knew, the child wasn't there.
we don't know how much time elapsed through all of that, but it was, she put her child to sleep, she took a double shot of vodka, and she went to sleep herself, and she doesn't remember anything else, and her mother woke her up and said, the child's at the hospital, why is the child at the hospital? And she didn't remember any of that. That evidence doesn't establish anything for purposes of an adjudication. We can certainly say it's not the prettiest picture for a parent, but it doesn't establish under the law, under the rule of law, the neglect or abuse.
Is it your contention then that you could not find the existence of neglect on the basis of a parent having consumed alcohol to some degree and then not being aware that the child was being removed from the house until the child had been taken to the hospital?
It is so difficult to say that a parent who puts their child to sleep, has a drink, goes to sleep themselves, must be aware of all of those kinds of facts. Even in Stumbo, decided by this court, the court recognized that every deficiency of a parent does not automatically rise to the level of neglect. I do want to address.
Before you do that, Justice Hudson had one other question I wanted to get in, and it's just a question of what does the record reflect. There was some discussion with your colleagues about whether the evidence the records had been admitted at the non-secure custody hearing before or after the appointment of counsel. Can you shed any light on that question?
Your Honor, I can only suggest that all of that occurred on the same date when the mother is served with process, her counsel is appointed, and the non-secure custody order is entered with the reasonable efforts report at that hearing.
So at least as you understand it, the record is not clear as to whether the mother had counsel at the time that hearing was held?
Counsel was appointed at that point. Now, what transpired in terms of the chronology of those events, generally these initial non-secure custody orders that are entered without counsel. Most of them don't involve counsel at all, the initial one. I want to speak to a couple of other matters important. The dependency adjudication. And I think the Court of Appeals has asked guidance of this court. Both Judge Dietz and Judge Inman asked that the legislature or this court give some guidance in the principle. And I want to suggest to the court that dependency is substantially different than neglect or abuse. When we talk about conditions that are alleged in a petition, dependency is a condition where there's a child who has no parent and no one else as an alternative caregiver to take care of them. Why would we adjudicate a child as a dependent if they've got somebody who can care for them at any point up to the point of adjudication? What is the purpose of that adjudication? Whereas with neglect, we're saying here are the conditions that existed that caused us to file this petition. And we filed this petition based on these conditions, not on, and if the cases AW and JR were neglect cases, we're not talking about that neglect, that condition that existed that caused the petition to be filed. In this case, this court and department had sufficient opportunity for non-secure custody order under the neglect and abuse allegations without regard to the dependency. They simply did not take the time to even investigate that issue, and they say that very clearly. We just didn't have time to do that. We don't know. I couldn't tell you whether they were good or they were bad. That's in the record. In fact, the Goodman home was approved in the record on May the 15th by signature of a department's agent.
What importance, if any, should we ascribe to the fact that the trial court said it didn't have time, in its estimation, to allow a home study to be conducted and didn't authorize DHHS to do that because of the exigency of the circumstance?
I don't have a bit of problem with that, but they can control that with the abuse and neglect. And in fact, by May the 15th, they knew that there was an alternative caregiver for the family, for this child. I also want to suggest that the mother did, in fact, propose prior to the filing of the petition, and that there was an alternative caregiver prior to the filing of the petition, and at the time of the filing of the petition. Cyrita Brown, the godmother, was proposed, and this family, when we look at the rule, I guess, that says, well, the mother or the parent has got to suggest the caregiver, really what we're saying is we're not going to allow an alternative caregiver to be part of the plan that the Department of Social Services or DHHS has. We're going to require some input by the family. This family showed up for this mother, and if you look at the orders, you will see family appearing in court with this mother. You will see family going to the department wanting to take care of the child, and they did that prior to the filing of the petition. So the dependency here did not exist. Dependency is a situation that was not necessary for this child. The evidence indicated it wasn't necessary. And what was the purpose of it? Why do we have the dependency? So it is an ongoing type of situation. If at the adjudication the child's not dependent, why adjudicate that child dependent? There's no purpose to it. It doesn't fit anything in the statute for why we have dependency as an adjudication. I've not had an opportunity to talk about the reunification issue. That is critical in this case. This is a mother who deserved an opportunity. She deserved that opportunity to be around her child, but she deserved an opportunity to show that she was not the person that everybody thought May 7th represented or May 8th represented. She was that person who could be a good mother, who was a good mother, who, given the opportunity, she showed her participation, her efforts. She showed she was deserving of that opportunity. There was no finding of a lack of success by this mother. She went above and beyond under the circumstances she had. I ask you to affirm the Court of Appeals.
Thank you, counsel. Rebuttal.
Yes, Your Honor, I'm going to try to limit this to 1 minute, if that's possible, so my co-counsel can have his minute as well. So first of all, the order on page 35, the order of May the 10th, does state that Attorney Jaron Dickerson was present for the mother. So I assume from that order, it appears that that attorney was present and representing the mother. It's not correct that the only evidence in the only evidence that supports the adjudications of abuse and neglect was the medical evidence. The mother's statements, which are admissions of a party opponent, do show that the mother had custody of the child on the night in question. The mother did drink the double shot of vodka, went to sleep, and when she woke up, the child was severely burnt. So all we need to show for abuse and neglect is the mother had custody and control of the child, and the child was severely injured. The only thing in the medical records necessary to prove neglect and abuse is the actual diagnosis. The stuff about the neighbor statements is just irrelevant, and there's no indication that the court relied on that.
I understand. I know you only have a minute, but I understand the position that hearsay evidence is relevant on the question of whether the trial court erred in eliminating reunification. But what's your response to the argument that the trial court's findings don't meet what's required under 7B 901C to eliminate reunification at this stage?
Well, the response is just basically, again, what I wrote in the brief, that if you look at the catch-all provision, it does say anything that can enhance abuse and neglect. And I think what we have here is severe injuries to an infant and the mother not even knowing how they happened. And I think that's another, issue. Whether she was not being truthful or whether she blacked out, I think both are very, either option there, I think, is very concerning when we're talking about reunification efforts with a small child.
And I see your time is up, but I do want a clarification. I heard the counselor on the other side speak to this, the burns like a sunburn. My understanding is third-degree burns actually burn away the skin. Can you comment on that in your last 3 seconds?
The only thing I know is partial thickness burns. That was what was in the medical records. So I didn't see anything that said second degree, third degree. Frankly, if they did, I don't know if that would mean that much to non-medical professionals such as myself. But we do know that there was a healing process that took several weeks, and then the wounds had to be cleaned and debrided, especially in the left foot, and that there was a foul odor coming from the feet, especially the left foot, and this didn't resolve itself for a period of weeks.
Thank you, counsel. Thank you to everybody.
Thank you.
Mr. Miller, we particularly appreciate you coming up from Greenville. Hope you've enjoyed the mountain view.
Thank you very much, Judge.
Mr. Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 11 a.m. God save the state and this honorable court.